noting that the President Obama's administration has been marked with an aggressive agency action and implementation of various agendas through mainly the regulatory process versus congressional action. And simply what that means is, outside of President Obama's first piece of legislation that he ever signed as a president, which was, if any of you recall, the Lilly Ledbetter Fair Pay Act, which he executed in 2009, there really have been no significant legislative, meaning congressional enactments that have affected your day-to-day human resources, other than the Affordable Care Act, which we will touch on today. But the administration has been able to carry out what has really been deemed an aggressive agenda, both in the press as well as through the agency's own words and its strategic plans. And they've done this through administrative rulemaking, or the less formal means of a formal administrative guidance or interpretation. So the question now becomes that we have a change in administration is what will happen when the new administration takes over in January. So for today's topics, we're going to review a number of those, or potential impact in a number of these areas, including initial discussion about judicial appointments and regulation and executive orders. We'll be touching on the status of the DOL's revised overtime regulations, particularly in light of the nationwide injunction that was recently issued out of the court in Texas. We'll talk about National Labor Relations Board policies and decisions. We will look at what is maybe a predictable future for the Affordable Care Act. We will discuss what Trump's administration, what impact he may have on the immigration policy, as well as what impact the administration may have on what has been a growing expansion of LGBTQ protection. So with that agenda in mind, I will now turn it over to my colleague, Jim, who's sitting in our Hartford office.
Thank you, Katie. Welcome, everyone. We're most pleased to have you with us today as we talk about what potentially a Trump administration impact may have on employers. I certainly think there will be an impact that will work its way out over time, of course. So if we could maybe change the slide, the forward one. I'd like to start my remarks on appointment of federal judges. And our court system, of course, is the ultimate referee of a lot of the regulatory and legislative enactments we've seen over the years. And it's possible that the Trump administration could have a profound impact on how the referees evaluate regulations and laws that impact employers. The most prominent vacancy, of course, is at the Supreme Court as a result of the death of Justice Scalia. It's almost certain that President Trump will appoint a conservative jurist, and time will tell who that person is. But below the Supreme Court, there are 103 vacancies in the federal court system, and 38 of those are deemed judicial emergencies, meaning that there's been a vacancy for at least 18 months, or a particular court's docket has exceeded a certain limit. Of the 103 vacancies, so there's 104 if you include the Supreme Court justice vacancy, but of the 103 vacancies below the Supreme Court, 13 are on Federal Court of Appeals, 82 are in the United States District Court, and then 8 are in so-called special courts, such as the U.S. Court of Federal Claims. The Supreme Court appointment is likely to preserve what has been in recent years a 5-4 conservative majority, but it's also possible, I would not say likely, possible that President Trump may have other opportunities to make appointments at the Supreme Court. Justice Breyer is 78 years old and usually sits on the liberal block of the court. Justice Kennedy is 80, and as most of us know, is considered a swing vote. Justice Ginsburg is 83 and sits on the liberal block of the court. Perhaps President Trump's most meaningful impact could be on the Ninth Circuit Court of Appeals. That's the largest Circuit Court of Appeals we have. It covers Alaska, Arizona, California, Hawaii, Montana, Nevada, Oregon, and Washington. It is considered the most liberal of the circuit courts. It has the highest reversal rate at the Supreme Court. In the upcoming calendar year, there will be 4 vacancies on the 29-member court. So, to give you a broader perspective, since 2009, there have been 55 federal judges confirmed to federal appeals courts, and 31 of those have replaced Republican appointees. It seems to us that there will be a lot of opportunity for the Republican administration to populate the court system with conservative jurists, and this is so not only because of a conservative view of the Republicans, but they will control Congress. So absent some Senate rules that could frustrate the process, it seems as though the Trump administration could make some significant headway toward a conservative judiciary. Keep in mind, however, that history has shown that a conservative justice doesn't always issue conservative opinions. And to give a couple of examples, Justice Souter, who was appointed by President Bush, turned out to be closely aligned with the liberal bloc on the court. And Justice Scalia famously wrote the 1998 opinion which held that same-sex sexual harassment was unlawful. So time will tell, but we definitely do believe that the judiciary will have a significant impact by the new administration. Can you go forward a slide, please? The most immediate impact to business is through federal regulators, and there are an array of them that can impact businesses, such as the NLRB, the DOL, which we'll talk about in detail, the EEOC, OSHA, OFCCP, Homeland Security, ICE, the U.S. Citizenship and Immigration Services, and the SEC. If anybody's looked at the Trump-Pence website, you will see what is styled as Donald J. Trump's vision. And in the vision, he says a number of things, such as he will ask all department heads to submit a list of every wasteful and unnecessary regulation which kills jobs and which does not improve public safety, and eliminate them. He's seeking to reform the entire regulatory code to ensure that we keep jobs and wealth in America, to end radical regulations that force jobs out of our communities and inner cities. We will stop punishing Americans for working and doing business in the United States, and issue a temporary moratorium on new agency regulations that are not compelled by Congress or public safety, in order to give our American companies the certainty they need to reinvest in our community, get cash off the sidelines, start hiring again, and expanding business. We will no longer regulate our companies and our jobs out of existence. And in fact, that refrain on regulation permeated the campaign and was one of the touchstones of the Trump-Pence platform, which leads us to believe that there will be a significant movement among the Republicans to tamp down the enthusiasm that our businesses have seen by federal regulators. What the ultimate impact is remains to be seen, but I think we'll see a number of less enthusiastic heads of these agencies that will carry out a more business-friendly agenda as promulgated by the new administration. I think we'll certainly see this at the EEOC, which last month released a very aggressive strategic enforcement plan. There will certainly be new head regulators at the EEOC, and I'm believing that we will have a new policy which centralizes rather than decentralizes decision-making at the EEOC by requiring districts and the general counsel to coordinate with what will be a majority Republican group of commissioners, rather than having the field offices, district offices, general counsel so much authority to prosecute cases. So we'll see. I'm fairly certain across the agencies a more business-friendly, less activist approach toward regulation than we've seen in the last 8 years. If we could please forward the slides. Much has been said about executive orders, and if you Google executive order, you will find an endless supply of news articles on them. Executive orders are just one type of presidential actions. All presidents have used them. Lincoln's Emancipation Proclamation was an executive order, and Teddy Roosevelt's establishment of internment camps for Japanese citizens was an executive order. They have become more prevalent in recent administrations as ways to work around Congress, and the Obama administration issued 278 executive orders. It's certainly likely that the Trump administration will eliminate or throttle back some of the executive orders, and in fact, he is openly talking about that. In our opinion, there's one executive order that stands out as being quite ripe for rollback, and that's the so-called blacklisting rule, which requires certain federal contractors to disclose data about labor violations. As many of you may know, in October, a Texas federal court enjoined that, which makes it quite a likely target for a rollback by President Trump. And as can we go forward in the slides, please? We've highlighted in the next couple of slides a number of the executive orders that could be vulnerable in the Trump administration. I'm not going to spend a lot of time detailing those because we want to save some time for probably what a lot of you are waiting to hear about, which are the Department of Labor revised overtime regulations. And with that, I'll turn it over to Katie.
Thanks, Jim. As everyone is probably aware, in May, the Department of Labor issued final regulations that substantially increased the salary level applicable to anyone who claimed a white-collar exemption from overtime. And just sort of as a step back, understanding that, what those overtime regulations relate to, there are certain exemptions. The predominant exemptions at issue were the executive, administrative, and professional exemptions, otherwise known as the white-collar exemptions. And there are actually, in reality, 3 components of those exemptions. One, you must pay the employee a salary or on a salary basis. So that's what is called the salary basis test. And then that salary had to be a minimum level, which prior to the change in the regulation was $23,660. And third, the employee had to perform certain functions or perform certain duties that were enumerated in the statute and regulations that had to be met regardless of what salary was paid to the employee. You can move on. So in May, what the DOL's revised regulations did was increase that second component, or the minimum salary, and the test went from $23,660 to $47,892. And essentially what the DOL said is that, all things being equal, if you have a salaried employee who otherwise performs certain administrative, executive, or professional functions, you must now, at a minimum, pay them $47,892. And unlike the presidential executive orders that Jim was just referring to, these regulations actually came about as a result of the going through the formal notice and rulemaking process under the Administrative Procedures Act. So the regulations, the final regulations came out in May, subject to some criticism and flack against the DOL because they refused to extend the comment period after publication of the proposed rules. That was really deemed to be a deliberate and kind of actually well-publicized effort by DOL to try to ensure that the regulations came out in time to thwart a congressional override through the Congressional Review Act, really determined by the date that the current then Congress was sitting. So we can go on the next one. As implemented, and this comes off the DOL website, originally anticipated to impact 4.2 million workers across the United States. And as you will see from the diagram, or at least from the DOL's perspective, interestingly, Florida ranked third, third behind California and Texas as one of the most impacted states in terms of the impact of these regulations. So given that these went through a formal rulemaking process versus just some sort of administrative interpretation, when the dust finally settled on Election Day, it appeared that the only way that a Trump administration could undo these regulations would have been from a formal legislative action to revise the Fair Labor Standards Act, or through the regulatory process of proposed notice and comment and rulemaking that implemented the rules in the beginning, or in the first place. That all changed on November 22nd. Judge Amos Mazant, out of the Sherman Division of the Eastern District of Texas, issued a preliminary nationwide injunction which barred the DOL and the Secretary of Labor from implementing the revised regulations. The case arose, it was the state of Nevada versus United States Department of Labor. It was actually, the lawsuit was actually brought by 21 individual state governments alleging that the overtime rule infringed on their 10th Amendment right in mandating how state employees would be paid. The interesting part too was that this was a consolidation as well by a second lawsuit brought by over 30 business groups, which included the United States Department of Chamber of Commerce, that argued that the rule was arbitrary and capricious under the Administrative Procedures Act. In essence, in granting the injunction, the court held that Congress intended that the plain meaning of the terms in the FLSA regarding the white-collar exemptions were dependent not on the salary but on the specific duties. And if you remember, I referred to the duties test earlier. And so from the court's perspective, Congress or the Department of Labor needed to focus on defining the duties that were related or that determined whether you're exempt under the Act and not the employee's salary. So the court reasoned that by increasing this salary so significantly, the DOL had effectively supplanted the duties test with a salary test, so it became a de facto salary-only test. Now, court, in doing so, didn't really reconcile the fact that the salary test had been administered had been in the DOL regulations since the 40s and had been, updated on any number of occasions and actually been tested over the years in different courts. And that's probably going to be one of the areas that's going to subject it to potential weakness on appeal down the road. The court also held that in these regulations there is a triennial or every 3-year automatic increase, which was brand new to the DOL regulations, had never been implemented before. And the court said if you have an automatic increase without going through the notice and comment period every 3 years, then you're violating the APA. Right now, the matter, it's a decision on a preliminary injunction, so it's not a final injunction. Ultimately, the court will have to make a final determination about whether the regulations violated the APA. Although, of course, by granting the preliminary injunction, the court's already kind of showed its hand and indicated that the plaintiffs have already established likelihood of success on the merits. DOL, of course, takes a very strong position in disagreement. This is from the DOL's website. It's their sort of postings. They strongly disagree. Again, recognizing that the salary basis and salary level tests have been a fundamental part of the exemptions since, really the 1940s. The DOL has already filed its notice of appeal of the opinion, and on December 2nd asked the Fifth Circuit to try to expedite the proceedings. Their position is that Judge Mazant's holding in Texas, in his opinion, is contrary to prior decisions that have come out of the Fifth Circuit on the salary basis test. You can go ahead. We hope you'll participate, a quick polling question, because we were curious, just from your all's perspective, how you have been dealing with these issues as they've come up. And so you can click on an answer on the right-hand side of your screen, but our polling questions are with respect to the Department of Labor's revised white-collar regulations that have increased the minimum salary test to the $47,892 per year level. Which of the following best describes your company? A, my company implemented changes to comply with the rules, but and has not rescinded those changes. My company implemented changes but put those changes on hold. My company had not previously announced or implemented changes. And D, my company is still unsure about what steps to take. And we'll give you a few seconds to place your votes. Interesting. Brandy, can they see this? Okay. So it looks like, from what we can tell, I'm not sure what the audience can see, but 50% of the companies represented on the webinar today have implemented changes and have not rescinded those changes. 17% of you have implemented changes but put them on hold. 25% had not previously implemented, and 8% are a little bit unsure. So it's a little bit of a mix, an interesting dynamic, and so we'll move on to the next slide. You're not alone. I think, what does this mean for your company in terms of where do we go from here? I think in the short term, obviously, for those of you on the call and for employers in general who have not implemented changes, had either not announced or had not finalized their changes, you have a little bit of breathing room. You can avoid liability in the immediate future from having to meet the new regulatory requirements. I think one thing to be very careful of, and should always be a concern, though, is that your compliance efforts under the Fair Labor Standards Act should not be diminished in any way by this ruling. And this goes back to what I mentioned earlier. When you look at the fact that there are really 3 components to the administrative, executive, and professional exemptions, and that is, the salary basis, salary level, and the duties test. And nothing in the new regulations changed at all the duties test, although there was some suggestion during the notice and comment period that the DOL might consider changes to the duties test. The final regulation that was implemented did not change that in any way. And so the reality is even if you're paying somebody the new salary at that $47,000 level, that alone doesn't make that employee exempt. So you have to meet all the tests. So, and obviously one of the stated objectives of the Department of Labor when they were going through this regulatory process was to get employers to take a hard look at all of their employment classifications. So obviously, if part of your compliance efforts to meet the new rule found that certain job classifications were not properly classified outside the salary level, the court injunctions wouldn't change that analysis. So, again, it's always important to continually monitor your job classifications and make sure that they comply with the duties test. The salary component is just one aspect of it. So then, and obviously, if you had not promised or enacted compensation changes as of the ruling, you're in the best position to maintain the status quo. If you've implemented changes in advance, and for some of you, you haven't retracted those changes, or and you're keeping the status quo, obviously there's nothing illegal about maintaining your status quo or paying your employees more than the regulation would require. If you do consider changing back the rates of pay, we just recommend doing it in writing and providing your employees some form of notice, because there are some states that actually require changes in compensation to be announced in writing. So what will happen with the appeal, or what is our prediction? Well, again, given timing, obviously the reality of a possible Fifth Circuit opinion, overturning that injunction, it could happen. You just don't know. But with a new administration coming on, there's a new, with that comes a new Secretary of Labor. And so a lot of it will depend on the appetite for the Secretary of Labor and the new administration and how they feel about these regulations. As of today, there is, I don't know that there's a real front runner for the Secretary of Labor. I think that may change on a daily basis. I think an early front runner for the Department of Labor was EEOC Commissioner Victoria Lipnick. She is formerly actually a former Assistant Secretary of Labor for Employment Standards and actually oversaw the last time that there were amendments to the overtime regulations, which was in 2004 when she oversaw the wage hour division. She was an early front runner. We're not hearing a whole lot about her now. Another potential person was Representative Lou Barletta out of Pennsylvania. He's met with President-elect Trump to discuss the position. He comes from more of a small business background, kind of a self-made small business, got into politics as the mayor of Hazleton, Pennsylvania, and then made his way into Congress. So he shows a sensitivity to government interference with business taxes and immigration issues. But I think as of today, maybe if you want to predict a front runner, it's Andrew Putzner, who doesn't come from a political background, but is currently the Chief Operating Officer for CKE Restaurants, Inc., which is the Hardee's and Carl Jr. Brand of restaurant chains. He has now met with President Trump twice about the Department of Labor position. He's been publicly critical of the revised regulations, and especially given the heavy impact that these regulations would have on the hospitality and restaurant business. He may bring a completely different perspective to the table than obviously the previous administration. So, and President-elect Trump's position is not exactly clear either on the regulations. Although he took very specific positions on certain platform issues, including the repeal of the Affordable Care Act, which we'll get into in a bit, position on the overtime regulations wasn't as clear. He, in fact, has promoted in the past raising of the minimum wage to $10 an hour, and he has spoken in terms of favoring a small business exemption or a nonprofit exemption to the regulations versus a complete repeal. So again, we don't know where he stands specifically, but so again, it may be more of a wait and see. Doesn't bring you a lot of comfort in trying to figure out how to deal with these issues in your business. But sort of sum this up by again just understanding that FLSA compliance, regardless of what happens with these regulations, will always be a hotbed issue for employers, and so to just make sure you keep up your compliance efforts overall. And with that, I'll turn it back over to Jim.
Thank you, Katie. We're going to now talk a little bit about the National Labor Relations Board. This is a entity that has typically swayed with the political winds. And if we could advance to slide one, that would be great. But I think it's fair to say that under the Obama administration, the NLRB has tried to assert relevance over industries that have not typically been unionized and been involved with issues under the NLRA. Policy and decisions of the NLRB are now reaching topics such as social media, employer handbooks, discipline, First Amendment rights, and even settlement agreements that companies enter into with former employees. So I think there's no doubt that under the Obama administration, more companies have seen the reach of the NLRB than ever before. Some examples that we're all familiar with now is the controversial decision defining a joint employer relationship. An interesting aside would be to read, if you hadn't already, Harry Johnson's dissent. Harry Johnson was a conservative member of the board who is no longer on the board, but Harry Johnson's dissent in that matter is particularly interesting, and I think most employers would find compelling. That, as you all know, had a significant impact on the franchisor-franchisee business model. We also saw the persuader rule, which is currently enjoined by a district court, but that imposed significant and extensive reporting obligations on lawyers who advise employers on unionizing efforts. the reach of the NLRB expands to the definition of concerted action, and that's where you see their entanglement in corporate social media policies and handbook policies, which before the current administration had not been subjects that the NLRB entangled itself with. I think you could look no more recently than some tweets that Mr. Trump sent out over the Carrier air conditioning deal, where he was in a war with Chuck Jones, the president of the United Steelworkers, 1999, and Mr. Jones was questioning the transparency of the deal, pointing out that 500 workers are losing their jobs in the Indiana plant, and Mr. Trump was very quick to respond critically of Chuck Jones and his efforts to save those jobs. And I think that will reflect the new administration's pro-business and more aggressive support of business than we've seen under the current NLRB. If we could proceed with the slides, please. So the NLRB members are appointed. They have to be confirmed by the Senate. There will be opportunity for President Trump to change the composition of the board. There are expiring terms upcoming, and perhaps most significantly, President Trump will have the opportunity to nominate a general counsel to the board. And the general counsel has a very influential sway over the board, very important position. And I think the administration has an opportunity to have a significant impact in that person's installation on the board. Some of the key cases that the board has been involved in that we think will get attention going forward include the subject of mandatory arbitration. The NLRB, as most of us know, has been very much opposed to the notion of mandatory arbitration. The courts have generally rebuked the NLRB decisions on that, but this is a hot topic, and I think, going back to my comments on judicial appointments, I think ultimately it's going to get to the Supreme Court, and it's likely that in a more conservative judicial environment, the notion of mandatory arbitration will be embraced and upheld. I mentioned briefly the joint employer definition. I think that will be revisited and probably rolled back to the definition that existed before the more recent NLRB ruling. I think we'll see a more gentle touch from the NLRB on social media policies and employment handbooks. In some, the notion of concerted activity under the NLRA. The new administration's NLRB is going to continue to address the unionization of college and graduate students, perhaps including student athletes at public universities. And of course, the persuader rule will be addressed. So in sum, I think that there will be a very substantial opportunity for the new administration to refocus not only the composition but the efforts of the NLRB, and I'm certain that we're going to see a less aggressive NLRB in the coming years. Katie?
Thanks, Jim. We'll now try to maybe look into a crystal ball and try to determine what is the future of the Affordable Care Act. I think even if you tried to avoid politics completely, I don't think you could avoid, sort of the the stumping and the campaigning in which President-elect Trump has made repeal of ACA a pillar of his platform. And now with a Republican-controlled Congress, he certainly has the support to carry out and execute that policy. Go ahead. Vice President-elect Mike Pence has been very vocal since Election Day, essentially, in arguing that that is actually one of the goals of the administration within the first 100 days of office. And President-elect Trump's selection of Georgia Representative Tom Price as the Secretary of Health and Human Services appears to be very consistent with that pledge. Tom Price, if you don't know, has been an Obamacare critic really since inception, and has proposed and has been part of the replacement plan architect in Congress over the last few years. Now, it still remains to be seen whether ACA will be repealed or amended, which are two very significant, can have very significant differences to it. And if it's amended, what the components of a new plan or what a Republican backed plan would have. And there is somewhat differences, it would appear, even between President-elect Trump's positions regarding certain provisions and what the Republican mandate or where the Republican alternatives have proposed. As an example, although publicly calling for a repeal, President Trump has actually advocated for the position that allows beneficiaries under the age of 26 to continue on their parents' plans, which is a current provision of ACA. He has also been a proponent of continuing the pre-existing condition exclusions. And that's an interesting dynamic, given that if you look at the previous versions of the Republican-backed Better Way plan, they had some, what they really called continuous coverage exclusions, not pre-existing condition exclusions. And the way the Republican plan worked was that if a beneficiary could show that they had previous continuous care for an 18-month period prior to switching plans, that only then could you not have a pre-existing condition exclusion. But without that prior coverage, you could implement a pre-existing condition exclusion for up to 18 months. So, I mean, that's kind of a vast difference from the way it currently exists under ACA, and frankly, that provision exceeded and is much more liberal than the previous HIPAA pre-existing condition exclusions that applied to employer-sponsored ERISA plans prior to ACA. So that'll be interesting to see what happens with those provisions. Another provision that was clearly at the forefront from the Trump campaign was repeal of the individual mandate, which is different than what impacts employers on a day-to-day basis, because the individual mandate was that component of ACA which dealt with the requirement that individuals, regardless of whether they were employed or not, obtain coverage or face individual tax penalties. According to Trump's website, no person should be required to buy insurance unless he or she wants to. And so while attacking the individual mandate, they were somewhat silent on the one that applies to, I'm sure, most of the folks on the call, which is the employer pay-or-play mandates. And again, as you know, that essentially what that means is you are an employer with 50 or more full-time employees, you are required to maintain certain types of mandatory coverage or face penalties. And those pay-or-play mandates, if you deal with HR issues on any level, also restrict or reduce the ability of an employer to change or reduce employee coverage because of the complex look-back and stability rules if you have an employee who reduces hours or is on a leave of absence. So whether those particular mandates, the employer pay-or-play mandates, survive an amendment, if not fully repealed, remains to be seen. There's another kind of what I think is a somewhat lesser known or maybe received lesser attention provision of ACA, which is Section 1557, which is the non-discrimination provision. And actually there were some recent amendments effective July of 2016 that were issued by Health and Human Services. Effective July of 2016, although if you had to make plan amendments, it was for plan amendments effective January 1, again, prior to the inauguration. But essentially, in essence, it's a non-discrimination. You can't discriminate against for covered entities with respect to, the typical race, sex, national origin, all those, the age, those types of things. But HHS actually took very liberal views of what is sex discrimination, and it provided additional protections based on transgender or self-identification. And so you could not deny coverage or treatment on the basis of gender identity for covered entities. And covered entity is somewhat defined broadly. It may or may not cover private plans, and that's where it gets a little tricky. If your private employer plan accepts federal funding from HHS through Medicare Parts A, C, and D, you could be considered a covered entity. Covered entities, for any of you on the call who are healthcare entities, you are defined as a covered entity under these regulations. And again, if your business is primarily healthcare, you're covered. As an example, a hospital, not only would they be covered in terms of the services that they provide to people who use their facilities, but they are it automatically covers their health plans that they have for their individual employees. And the other interesting component of that is it moves enforcement to Health and Human Services and the Department of Justice, which is very different from what, as an employer, you're used to in dealing with DOL or the Department of Labor oversight for your ERISA-governed plans. And so there's somewhat of a conflict and a friction there, and DOL really hasn't come out and provided any guidance yet on kind of reconciling the impact between the HHS rules and the ERISA rules through the DOL. The other kind of interesting component of those provisions is that if HHS gets complaints about employer plans and the employer happens to not be a covered entity under these HHS rules, they are supposed to turn over those complaints to the EEOC. So it's a bit circular because, again, and as we'll get to a little bit later in the program, the EEOC takes a position that opens up the definition of sex discrimination that maybe hasn't been approved in the courts. But so your plans could be looked at, even if you're not covered by these non-discrimination provisions, you may be looked at by the EEOC as being covered. And if you have plans that don't cover gender identity or even have outright exclusions for gender reassignment surgery, you could be falling under the EEOC's jurisdiction as a result of these regulations. Ultimately, again, because they're going into effect or have been effective as of July, but for plan changes effective January 1 of 2017 before the inauguration, if Secretary Price gets, or President, I guess it's elect Secretary Price, is nominated and approved by the Senate, he will be now head of the organization, which will be tasked with looking at these regulations. So they're on the books. Whether they will be repealed or revoked outside of a full ACA appeal still remains to be seen. But I think all of it just shows that it's easy to talk about a repeal of the Affordable Care Act, but there are a lot of moving parts. And so any legislative amendments will obviously take some time, particularly when you consider that according to HHS, there have been 20 million additional individuals insured under ACA's provisions since it was enacted in 2010. So it's a lot of people, a lot of folks that have to be taken into consideration if they implement a full repeal. But those are just some of the issues that I think, from an employer perspective and your plan perspective, to be on the lookout for. And I will turn it over to immigration.
Well, during the campaign, President-elect Trump made a lot of statements about immigration, some inflammatory, some mixed. I think that we can all agree there will be attention, if not change, on some of our immigration measures that we've seen under the prior administration. There is definitely the potential, if not reality, that under the new administration we'll see increased scrutiny of companies' e-verification, their I-9s for workers. This would include audits by ICE, and it would be well advised, to the extent companies haven't done this already, to be proactive on that and have as part of your regular checkup a review of your I-9s, so-called I-9 audit. There's been a lot of commentary and discussion, too, on the so-called H-class visas, particularly the H-1B visas, which are issued to 65,000 workers and 20,000 graduate students. These are for highly skilled workers in specialized industries. And 65% of those, as of 2014, were in computer-related occupations. Some of you have probably seen Senator Sessions' critique of the use by companies, American companies, of H-1B visas. And I think President-elect Trump has expressed some concern that companies are using this process to avoid paying more money to hire domestic employees. I don't know where this will shake out. It's certainly a very critical and in some respects controversial topic. Mr. Trump has made statements opposing the Deferred Action for Childhood Arrivals, so-called DACA, and the Deferred Action for Parents of Americans, DAPA. We don't know where that's going to end up, but certainly those both impact employers and their families. So immigration, of course, has been a debated topic for various administrations without certain results. I don't know what the Trump administration will be able to achieve, both either legislatively or on a regulatory basis, but there will be continued debate, discussion on the topic, and we could spend an hour at least talking about that. Those are some of the things, though, that are on the horizon, and certainly I think the H-1B visa will be a hotly debated topic for the next 4 years. Katie?
Thanks, Jim. Despite Supreme Court decisions on same-sex marriage and/or local or state laws in your jurisdictions that recognize sexual orientation discrimination, technically no circuit court to date has held that Title VII protects sexual orientation discrimination as sex discrimination. You can go to the next slide. Interestingly, though, the EEOC is kind of undeterred in that and has been aggressively trying to expand the definition of sex discrimination under Title VII outside of legislation to encompass sexual orientation and gender identity. This is frankly despite the fact that, at least since 1994, every year there has been some amendment or some proposal in Congress, either through the Employment Non-Discrimination Act or the 2015 Equality Act, to try to amend Title VII specifically and other federal laws, including Fair Housing and Equal Credit Act and those types of things. And it's never passed Congress. It's either not gotten out of committee or they never had enough votes to actually legislatively change Title VII. And so, again, EEOC, though, doesn't seem to be deterred by that and has taken the position in a number of courts. And there have been, frankly, a growing number of lower court decisions that have found some form of protected status for sexual orientation and transgender discrimination under Title VII, although largely those come about as a result of theories that relate to sex stereotyping claims versus a per se theory of the sexual orientation discrimination. In other words, it's the perception of what should be considered gender norms is a form of sex discrimination versus finding that somebody is protected from just the fact that they are a gay or transgender employee. And again, circuit courts to date have not gone that far. They're unanimous in their decisions that outright sexual orientation discrimination is not protected by Title VII, but that may be changing soon. There are two cases that we wanted to highlight, bring to your attention to kind of be on the watch for, because they raise some interesting issues. The first is the Hively versus Ivy Tech Community College case pending in the Seventh Circuit. Kimberly Hively was a part-time adjunct professor at a community college in Indiana for a number of years. And she was part-time, but applied for 6 different full-time positions over a 5-year period. Not only was she not hired in the positions, but she never even was interviewed for the positions. And then her part-time contract was eventually not renewed. She sued, alleging that the decision was motivated purely by the fact that she was a lesbian. The trial court granted the defendant's motion to dismiss, finding that Title VII, as the circuit courts have held, do not protect claims of sexual orientation discrimination. Again, Ms. Hively did not bring a claim under the gender stereotypes as a form of sex discrimination, but just on the mere fact that because she was a gay employee, she was being discriminated against. In late July, a panel of the Seventh Circuit upheld the dismissal, explaining that it was bound by its prior precedent, also in the Seventh Circuit, that sexual orientation was not protected. But it was a fairly lengthy opinion. It kind of went through the history of the law here and indicated, frankly, that they were sympathetic to her plight, but felt bound by the fact that neither the Supreme Court or Congress had changed the definition of sex discrimination under Title VII, and it was simply not recognized. They also, though, kind of recognized that the seeming gap between protections for those who brought claims for sex stereotyping versus Ms. Hively's claim of a pure because of sexual orientation discrimination. And it's likely that that is kind of what got the attention, or at least may have been the impetus for a kind of unprecedented move by the Seventh Circuit in withdrawing the July opinion of the panel and granting Ms. Hively's motion for rehearing en banc in front of the entire Seventh Circuit. So that motion was granted in October, and on November 30th, just a couple weeks ago, that they had oral argument in front of the entire panel, and it's under advisement now. So if the en banc Seventh Circuit changes course and holds that under some theories that Title VII encompasses sexual orientation, there will now be a split in the circuit that could tee up this issue definitively before the Supreme Court. And then kind of going full circle again to where we started this presentation, which is if there is a Trump-appointed Supreme Court justice that could impact the landscape, absent congressional action. The other decision is, I may butcher this name, but the Gloucester County School Board versus GG. And this is the case that's actually already had cert granted for the Supreme Court. And it's arising out of a Fourth Circuit decision that had granted a preliminary injunction allowing a transgender student from Virginia to use the restroom, locker room, and other facilities that matched his gender identity. In this case, it's not brought under Title VII, but it's brought under Title IX, and it's specifically deciding whether a Department of Education policy or a policy statement in a letter that was provided to the student that Title IX's definition of sex includes protection against gender identity discrimination should be upheld. So again, it's not a Title VII case, but I think that a Supreme Court opinion here could very well inform an eventual Title VII challenge if it comes in through Hively or through some other means. Go on to the next slide. So it kind of raises the broader question of what will the EEOC look like under a Trump administration, and I know Jim touched on this briefly, but just by the numbers, there are currently 5 members of the commission, 2 deemed Republican, although the chair is obviously a Democratic appointee. President-elect Trump will get to appoint not only the chair of the EEOC, but he will get to appoint the EEOC's general counsel. And then 2 of the Democratic commissioners have terms set to expire in 2018 and 2019. So again, it begs the question of what will happen to some of these aggressive policy considerations or some of the positions the EEOC has taken from a regulatory standpoint. And and from my perspective, I'm extremely curious on what will happen to the revised EU1 pay data regulations that were promulgated just this year. And for those who may not have been keeping up with it, the revised regulations, if you are an employer with 100 or more employees, you file annually an EEO-1 report. That's been around for many, many years. And that report basically requires you to identify, in general categories, the number of male and female employees by race and national origin. And that's the current rule. And you do it in 10 different employment categories. The EEO-1 revised rules from the EEOC, though, have just come out, and they are now going to be requiring, effective in the report that is due in 2018, significant pay data information in addition to the race, sex, and ethnicity information on the charts. And so in all of those categories, in the 10 employment categories, employers will be required to also identify in 12, for all of those employees, which of 12 different pay bands those employees work out of, as well as total number of hours worked. Again, kind of went through, there was a lot of criticism about these rules. Obviously businesses and employers are not happy with these rules. So it'll be interesting to see if these rules may be the first on the chopping block to go. But so right now they're on the books, but there's a little bit more time for this, unlike the overtime rules that were effective supposedly on December 1st. The administration has some time between now and 2018 to see if they'll tinker with these rules. Okay. Oh, now we're on the infamous course code. For those of you who want to apply for CLE credits, when you fill out the form, the course code is 4, N as in Nancy, 1, 2, W as in whale. Again, 4N1 2W, and it will be on the contained in the PowerPoint. I think that you would be able to access. If you have any questions about any of your CLE forms, I'm sure our marketing folks will be happy to assist in that process. So at this point, we're at that point in the program. If you have any questions, I know, Brandy, you can file in the right, I think the box is in the right-hand corner. Type in any questions you have, and we will see them.
Okay, great. I think we have one here, so I'll go ahead and read this out, and feel free to continue to submit. But the question we have is, regarding the overtime rules, what happens if the regulations are found to be valid, but we did not implement changes pending the injunction? Can we be deemed in violation retroactively?
That's a good question. And we'll give the typical lawyer response, as it probably depends. In theory, if the rules were supposed to be implemented on December 1st, and so by final regulation, employers should have been in compliance on December 1st. Right now, there's obviously a stay in place on those policies. But, you know, this happened back, I want to say in 2015, that the Department of Labor changed the rules for home health care workers and made them actually change to make home health care workers subject now to DOL rules. And there had been a preliminary injunction entered that finally worked its way through the appellate court system, and in that time, and ultimately upheld the rules. So the DOL rules were found to be valid ultimately after challenge. And, you know, the courts are kind of split right now on the litigation that's come out of those rules, in terms of there have been some plaintiffs' lawyers who brought FLSA lawsuits that said, you know, we're seeking back pay all the way to the effective date of the regulation, despite the stay that had been entered in the injunction. And some courts have been dismissing those claims, some have not. You know, again, it'll just have to shake out. But in theory, if you were supposed to have effective date of December 1st, a court might find that you should have been in compliance ultimately if that provision is upheld.
I would add, Katie, too, that in the new administration, though, you will have a more conservative approach by the Department of Labor that I believe will be sensitive to this question. And should the result be as the questioner poses, my sense is that you'd have some administrative action that would alleviate any harsh impact on businesses. But again, as Katie said, that's a guess. but my sense is that's a pretty good educated guess.
Great, thank you. We have an additional question, and this is in regards to Executive Order 13706. The question is there going to be any forms created for the employees to fill out? For example, FMLA leave requires paperwork for approval of leave.
Yeah, the question pertains to the executive order mandating that federal contractors provide a minimum of 56 hours or 7 days of paid sick and care leave for its employees accruing on day one of employment. And that was one of the executive orders that we hurried through, but was on slide number 8 for those of you who print out the slide deck. I don't know for certain what the answer to that would be, and I get back to two things. One is whether or not there's an appetite in the Trump administration to roll that back, and we've seen some mixed signals from the Trump administration on family medical leave for families. It's also a rather narrow order in the sense that it pertains to federal contractors, so it may not immediately draw attention from the administration. But the other thing I'll harken back to, which I said moments ago, is that in the new administration, you're going to have a different approach than you would have had under the Obama administration. So I'd have to say just wait and see.
Great, thank you. To be respectful of everybody's time, I think we will conclude the presentation today. Thank you very much, Katie and Jim, for your very insightful views on what's coming up, and thanks everybody for joining us. If you have any questions or comments about the information presented today, please feel free to contact us. If you have submitted a question that we have not addressed, we will reach out to you individually. Thank you and have a great day.